you will be required to go to mediation for your family law case, but you will not be forced into accepting an outcome that you're not comfortable with. Today I'm going to talk about something that's a crucial part of just about every family law case, and that is mediation. So what exactly is mediation? Well, think of it as a facilitated discussion aimed at resolving disputes. Now in Georgia, almost every family law case must go to mediation before it can head to trial. There's a few exceptions, but I won't get into those. So let's start at the beginning. A case is filed and then it's served. Okay, and so some cases are easy and they can be resolved between the parties, or maybe between the parties and their attorneys. Probably about 25% in my experience. But what if that doesn't happen? Can you go right to trial? Well, in Georgia, most likely the answer is no. Now you may wonder, why mediation? And the reason is it's an opportunity for both parties to sit down with a neutral third party, the mediator. And the mediator is like a trained guide, a facilitator who's there to help you navigate through the muddy waters of your disagreement. So they're neutral and they don't take sides. Their goal is to assist both parties in finding common ground and reaching a resolution that works for everyone involved. Now here's the thing, while attending mediation may not be optional, reaching agreement is entirely voluntary. You will be required to go to mediation for your family law case, but you will not be forced into accepting an outcome that you're not comfortable with. The power to agree or not to agree is in your hands. So the way that mediation works is that the two sides of the case are typically kept apart from each other and the mediator goes back and forth between them. Maybe you've heard of shuttle diplomacy. We used to do this actually live in person. Now most mediation takes place on Zoom. So picture this, you're in a room with the mediator, could be a Zoom room, could be a physical room, and the discussions are underway. And it might be challenging and emotions might run high, but the goal is resolution of your case. If, however, an impasse is reached, meaning an agreement seems impossible, don't worry, it's not the end of the road. The next step in the event of an impasse would be a hearing. Now the type of the hearing depends on the status and the nature of your case. What I mean is it could be a temporary hearing to address immediate issues in the case that can't wait for the final hearing, or it may be a final trial if all of the interim steps have already been taken, if the discovery window period has elapsed, etc. So remember that mediation is an opportunity to take control of your situation and work toward a resolution that makes sense for you. It's a step down the path of eventually resolving your case, and it's a way to potentially avoid the more formal and adversarial nature of a trial, as well as the costs that are involved. So how do you prepare for mediation? Work with your attorney to make sure all of your information has been gathered and shared with the other side per the discovery requirements, and make sure that you have all their information that they're also required to share in discovery. There's no tolerance for ambush tactics in the court system, despite what you may have seen on TV or in the movies. And before heading into mediation, it is essential to be clear about two things. Pay attention here. The first thing is your ideal outcome, and the second is your bottom line. That is the least favorable position that you'd be willing to accept. Now, knowing these 2 points will help you navigate the mediation process more effectively, because as long as the negotiation leads to an agreement that fall between these two outcomes, your ideal and your bottom line, then you know that you can accept anything in this range. A huge mistake that I see people make in mediation is that they sometimes want us to argue their case to the mediator as if they're seeking the approval of the mediator. But please keep in mind that the mediator is there to assist, not to favor one side or the other. And approach mediation with an open mind, be willing to negotiate, and most importantly, advocate for your needs and interests. Surviving mediation and being successful at this process is about finding common ground and also keeping in mind that a resolution that you and the other party create is almost always going to be better than what the judge comes up with. Keep that in mind, and that mediation does not need to be an all or nothing thing. For instance, divorces have many components. You've got child custody and holiday schedules. You've got asset division and debts and cars and houses and retirement accounts and division of physical property and even more than that. It's very common for parties to reach a partial mediated settlement agreement that resolves some of the issues. And then if you have to go back to court, at least you're only going to court on 2 or 3 issues rather than 6 or 7 or however many I just listed. And there's more. So keep that in mind too. Resolving some of the issues is better than having an all or nothing posture. Hey, thanks for watching this video. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us some comments and ask questions. Tell us what other topics you'd like for me to talk about. Join our Facebook group at Georgia Divorce and Custody for more information. And as always, I look forward to seeing you on the next video.